Good evening, everyone. Well, first of all, I would like to express my gratitude to the organizer of the event, Susana, Igor. This is my fourth or my fifth time here in Dubrovnik, so for me, this is the September event on Maritime. My presentation was on the European legislation on artificial intelligence system and its possible application or not to the autonomous navigation. Okay, I think we can put this on full screen. Okay, it's okay. Just a very brief introduction. We are, no, it's okay. It's okay? It's okay. We are all of you know, we are talking about this on yesterday and today in a moment on a disruptive technologies in commerce and transaction. This is the second phase of this kind of technologies. The first phase was at the end of the last century with the electronic communications, with the that kind of technologies. And this second phase is characterized by the artificial intelligence. And transport sector, and in particular maritime transportation, is at the forefront of these technologies. As you can see, electronic documentations, for example, brochure and rules on electronic documents, model law on electronic transfer of records, the United Kingdom Act on electronic bill of lading or electronic documents, etc. So we are in that moment of electronification or digitalization of the documents. We are in the moment on to apply the technology to decarbonization, so using the technology to reduce emissions to the atmosphere. We are in the moment, as previously Professor Filippo talks about port automatization and logistic chains with terms such as smart ports, tokenization, traceability of the goods. And obviously, we are in the moment of the unmanned navigation. With terms as a remote control, all of those has mentioned by previous speakers, remote control, artificial intelligence system, autonomous navigation, etc. Regarding the autonomous navigation, there are, in my view, and many of you have mentioned before, two different challenges. The navigation challenge, that is focused by the EMO. The EMO is focusing its efforts on the creation an administrative body of rules, an administrative scheme, that is the mass code, necessary to give access to the navigation, the autonomous vessel. This is the navigation problem or navigation challenge. And many of you have mentioned about this problem and what happened with the mass code, etc. However, another problem is the contractual and non-contractual liability for damage that might be caused by autonomous vessel or by autonomous systems. And in order to solve this problem, we have, in my view, two different approaches. The CMI approach, that is to identify the liability problems in the international conventions. For example, what's happened in case of a collision of mass? Okay, we are going to amend the collision convention. What's happened in case of seaworthiness of mass? Okay, we are going to change or to amend the exit rules or whatever. Or in case of pollution, or okay, we are going to change the CLC or the Bankers Convention, or okay, the limitation liability convention, etc. And another approach is the European Union approach, that is to create a general liability scheme for the artificial intelligence. And very briefly, Professor Miss Mudrik has mentioned how the artificial intelligence system works, but it's just a reminder. It's just probably all of you has used in the last 2 years ChatGPT. ChatGPT is an input. What is the input on ChatGPT? The prompt you write on the chat. And what, for example, okay, write a tale of a family living in Italy with 2 kids and an extension of the tale of 2 pages. This is the prompt that at the end is an input, is information to the system. Then the set of rules, this algorithm, programming, learning machine, deep learning, etc., make the magic, okay? And those set of rules obtain an expected result. And this result is the output. The output in form of decisions, actions, recommendations, in our example, the tail. So you can see on ChatGPT the tail with 2 pages extension. Obviously, the benefits of artificial intelligence are amazing. No, I put celerity, simplicity, and effectiveness to solving multitude of problems. However, the combination of the algorithm programming, the self-learning, the autonomous decision, the dependency on data, we will have a lot of problems with the dependency on data, because depends on the quality of the data, depending on the quality of the data, the output will be good or will be not. So the combination of all of those elements probably is going to obscure the allocation of risk and liability on the basis of traditional principles. The problems of the artificial intelligence systems in terms, I'm going to focus on non-contractual liability, those are an example, complexity in determining the cause of damages, because the behavior, and I say the word behavior, of the system, the human-machine interaction, the alteration between modes of operation, supervised, automated operation, so whatever, make it difficult to identify the origin of the error, the origin of the fault in order to attribute that fault. The black box effect is because, as I said previously, the system, the set of rules operate with opacity, with the internal decision-making problems. What is the decision-making process of the artificial intelligence? So it's quite difficult to understand. The unpredictable behavior, the evidentiary difficult for the victims, and I'm going to talk about this in a moment. Providing system failures, causal link to the damage, fault in the decision, or the implementation of the artificial intelligence systems can be extremely difficult, the proof for the victims, because, okay, when you have 2 ships and one in a collision, okay, you have some problems, but at the end of the day, there is a collision. But what's happened in case of a decision made by an algorithm? So we have a lot of problems related or in terms of non-contractual liability associated to the artificial intelligence system. In order to solve those challenges, the European Union, and I'm just talking in general, not in maritime law, but in general, the European Union has faced several dilemmas. In my point of view, 3 dilemmas. The first one is to renew or adapt. And probably this dilemma is the same dilemma as the EMO faced 2 or 3 years ago, or at the beginning of the study on autonomous ships. And the dilemma is, okay, formulate specific liability rules for the artificial intelligence or accommodate general liability rules on the specification of the new technology. First dilemma. Second dilemma, advocate a strict liability regime under the theory of risk. So if we have risk, okay, then the consequence is strict liability in case of damage caused by artificial intelligence, or maintain the fault-based approach. And the third dilemma is decide on the level of legal uniformity in the European Union for damages. As a result of those 3 dilemmas, the European Union has drafted a framework for artificial intelligence focused on non-contractual liability. we have 4 different pieces of legislations. Well, in fact, 3, because one is probably never being enforced, never being applied or approved. But 4th piece of legislation. The first one is the resolution with recommendations on a cyber liability regime for artificial intelligence. This is the resolution drafted on October 2020. The second one is the proposal of a directive adapting non-contractual liability rules to artificial intelligence. This is the Artificial Intelligence Directive, as Ms. Omujic mentioned before. I put in capital words the difference between, as I mentioned, as Will mentioned, the first one is try to create a comprehensive regime, very ambitious objective. But the second one is just to create just some rules on artificial intelligence. The third one is the directive on liability for defective products. This directive does not deal specifically with artificial intelligence, but in the concept of product, mention the software. So at the end of the day, the artificial intelligence is a set of algorithms that is a piece of software. And lastly is the Artificial Intelligence Act, or the regulation laying down harmonized rules on artificial intelligence. This is the regulation 2024. So I'm going to focus in this presentation very briefly in the first 2 ones. Regarding the first one is the resolution on liability regime 2020. As I said, the objective is create a comprehensive or entire regime for non-contractual liability for damage caused by artificial intelligence. What are the key points of this resolution? The scope of application is activities or process driven by systems, artificial intelligence system causes damages or economic loss. Identify the liable person in the or under the term operator. And we have 2 different kind of operators, the backend or the front-end operator. I'm not going to enter in the definition, but at the end of the day is the person who defines the feature of the technology and control the risk connected. And create 2 levels of liability rules for different kind of risk. If we are under high risk functions of the artificial intelligence, attenuate strict liability. Why I say attenuate? Because exclude liability of the operator when the damage was caused by force majeure, but strict liability at the end of the day. And a second level of liability is when we are under non-high risk function of the artificial intelligence and establish a presumption of liability for fault of the operator. Additionally, limit the liability in 2 million for personal injury or 1 million for property damage and economic loss in a period of 30 years, and create or mandate a compulsory liability insurance. If you look at the screen, all of the terms I put on the screen, person liable, strict liability, full liability, limitation of liability, insurance, all of those terms are quite familiar for us because this is an entire regime for non-contractual liability. Similar, if you look at the CLC Convention, or if you look at the Bankers Convention, or any other international convention on non-contractual or even contractual liability. The problem is this proposal was overambitious for the European Commission and has not apparently been followed by the European Union. The second piece of legislation in terms of our artificial intelligence is the Artificial Intelligence Directive. This directive, more modest, if I can say, introduced procedural rules for claims. Okay, so in order to help the victims to identify the responsible and try to prove the fault. This directive only applies to non-contractual claims for damages, and this directive identify the responsible in the person or of the provider or deployer of the artificial intelligence systems, or in the person of the user of the artificial intelligence systems. Both terms, deployer and provider and users, the directive refers its definition to the Artificial Intelligence Act. Formulates, as I said, rules on evidence, presumptions of fault, and presumption of the link between the fault and the output of the artificial intelligence system. And quite important aspect of this directive, as Miso mentioned before, does not affect the rules on the European Union regulating conditions of liability in the field of transport. What does it mean, this expression, that the convention or the directive, does not apply to the European Union legislation on liability in the field of transport? Under my point of view, the meaning of this sentence is nothing. Why? Because if you look at the scope of the directive applies to non-contractual, so exclude the contractual claims, and only European legislation refers to transport. It's difficult to find European legislation for non-contractual liability in the field of transport. It's quite difficult to find because transport rules on contract liability on the European Union are excluded in the scope of the convention. Transport rules on non-contractual liability, many of them base its applicability to strict criteria, on a strict liability criteria. And again, it's excluded to this directive because this directive applies only to fault-based approach or fault-based liability. And rules on right of passengers, quite important in the European Union, do not regulate liability. So at the end of the day, there is nothing on the European legislation to affect this directive. What is the? I'll try to make a graph, to make a compose of the different phases or stages of this directive. We have the operator, as I said, the provider or the responsible for software deployment. We have the output, the artificial intelligence functioning, expected or unexpected. If the function is unexpected, create damages to the potential victims or to the victims. Okay? So what is the process of this directive? The directive says, the victim have to prove, or the victims, have to prove the causal link between the output and the damage. Okay, remember the output is made by the artificial intelligence system, and the damage is obviously the damage. So the victims have to prove the causal link between output and the damages. In order to help to the victims in this process, the directive gives the victims the right to request relevant and necessary information to the defendant, then to the provider or to the responsible for the software deployment. If this person, I'm going to refer as the operator, if the operator not fulfill the requirement, the directive allows the court to request such information. And in case the operator fails to produce such information, the directive establishes a presumption of fault of the operator. Okay, so we have now a presumption of fault of the operator. The second stage or the second step is once the victim has the information, or once the directive presumes the fault of the operator, the victim must prove the fault. Okay, so the directive says, okay, victim, this is the information of the system. Try to prove, okay, good. Try to prove the damage. And then if the victims, or once the victims has proved the causal link between the output and the damage, the directive creates another presumption, another juris tantum presumption, or in terms of the directive, a rebuttable presumption, not on the causal link, but on the link between the operator and the output. This is the second link. So the directive creates, as I said, a presumption, is a rebuttable presumption or juris tantum presumption of link. This presumption is conditioned to the existing negligence in the conduct of the operator in the obligations refers on the Artificial Intelligence Act or in the directive. So if we have a presumption on the operators and the output, on the link, we have a presumption on causal links between the output and the damages, we have the solution of the liability system. If there is legal compliance for the operators on the obligations of the artificial intelligence system, there is no fault. So there is no fault, then there is no liability, there is no compensation. If there is fault because the operator has failed on the obligations, then the fault exists, and then the compensation to the victims exists. Okay. So this is, you can see the three different the two pieces of legislations, the resolution 2020 and the directive 2022. And in the left side, the rules or the liability rules on maritime law. As I said, between resolution 2020 and rules on maritime law are quite similar, because both pieces of legislations create or identify the person responsible for the damage. In one case, in maritime law, the owner, the ship owner, the register owner, okay, but in general terms, the ship owner and the operator for the resolution 2020. Both legislations of both rules apply a strict liability systems, channeling the liability to the ship owner in case of maritime law rules, both cases create a limitation of liability, a compulsory insurance regime. The problem is the Directive 2022. This directive, as I said, does not create a comprehensive regime of liability. Just mention some rules on procedural aspects regarding information, regarding the evidentiary aspects, or regarding the presumptions. Okay, and lastly, the conclusion. Sorry for the text, but in a sum up and in the last 1 minute, exist some doubts about the proposed European Union scheme applied for autonomous navigation. And why? Because in terms of person held responsible, maritime law identify the ship owner. Most maritime law conventions identify the ship owner as a responsible in case of damages. The European legislation identify the deployer or the operator of the system as the responsible for damages. So we have the first difference. Ship owner versus operator of the artificial intelligence systems. And secondly, in terms of burden of proof, the European legislation put the burden of proof on the victims with some helps, with some, as I mentioned before, with some helps on information and presumptions, but the burden of proof is on the victim side. Additionally, if there is no proof of the causal link or there is no proof of the damages, there is no compensation. However, in maritime law or under maritime law rules, the burden of proof, with some exceptions, as a fault legal note, for example, but with some exceptions, the burden of proof is on the ship owner's side. So those differences, the final question is, are those differences so important to exclude the application of European Union legislation for artificial intelligence systems or not? I think, and I finish, both instruments will be compatible because maritime law or rules on maritime law create an entire comprehensive system on liability rules. So if you look at CLC convention or banking convention, a comprehensive regime. And the directive could serve as a complement, as a procedural rules for the international conventions on liability. That's it. Thank you very much.
Thank you very much indeed. Any immediate questions, comments?
Juan Pablo, thank you very much. This was really helpful. I declare my complete ignorance. Can I just ask you a question for clarification? You divided very helpfully expected and unexpected outcome. You said if there's an unexpected outcome, this is where the liability is triggered. If the outcome is expected, then this whole thing doesn't work.
If it's unexpected.
If it is expected, then it's fine.
Okay, it's fine. That's fine.
Now, this is my question. Sometimes in real life, you find yourself in situations where you have to choose between two evils. Okay? So imagine a super tanker which in dire straits, difficult navigation situation, very heavy weather, no communication, whatever, and in collision course with a passenger ship. Okay. Now, you have to stress them all. So you have a system which has been designed to preserve the environment and human life, but then you need to prioritize. And the system does prioritize human life as it should be over the environment. So the machine decides to strand the ship rather than collide. And therefore it creates a huge disaster. That would be an expected outcome in this scenario, because the machine has been programmed to exactly that. Am I right? And is there a regulation about how to make that program?
Yeah, your example is quite similar in other, for example, you look at the autonomous cars. If the car is programming to avoid the accident or not to avoid the accident. If you read the directive is thinking on the expected result. Only in case of unexpected result, the rules are going to apply. The problem is, why in your example, why that result is, it's an expected result because the program is, or the system is programmed to do what you mentioned. So in that case, in my opinion, the directive shall not apply. But you have any other rules on artificial you have any other rules to in that case collision conventions or whatever, CLC or whatever convention, depends on the But in my opinion, the directive is thinking on in case of unexpected behavior of the system. Okay, but yeah, sorry.